today I will be speaking a little bit about the detached worker exception in employment law for employees who have been seconded to the European Union or likewise have been seconded to the United Kingdom. So luckily we have been granted the exception of the detached worker, which means a lot in terms of social security and where we're at with that. Some definitions of what this exception of detached worker actually means. So if a UK employee has been sent to the EU after the 31st of January of this year, then they will still be able to work there and only pay national insurance contributions as normal, and they won't be subjected to any social security contributions in the EU country. And this is the same for EU citizens coming to work in the UK. They won't be subjected to any of our national insurance. They will just have to pay their social security as they are doing in their home country. There are some rules surrounding this. So firstly, the posts cannot exceed 2 years. They can only work in this place for 2 years. And the second rule is that they cannot be sent to be replacing another detached worker. So under the Social Security Coordination Protocol in the EU-UK trade agreement, there is a general rule that social security contributions from the employee and employer should only be made in one country, and that would be the physical place where the employee is working. However, under the protocol there's also the exception of the detached worker, and this would mean that the employer would only have to pay social security contributions to their home country, and that's what I'm going to discuss a little bit more now. In Iceland it differs as well. For UK or EEA nationals, they will still have to pay their national insurance contributions as normal for up to 52 weeks. They may also be subjected to social security contributions, and there is the possibility of the detached worker exception for non-UK and non-EEA nationals for up to a year. This is possible to be extended to 2 years. So for employees who have worked or moved to the EU for secondment before the date of the 31st of January 2021, the rules will generally be that they pay social security in the country that they are now working and living in. In Liechtenstein, it's quite similar to Iceland in the sense that UK employees will still have to pay their national insurance contributions, but they may also have to pay social security contributions. So the question also arises, what about the employees who work in both the UK and the EU? So there is also an exception in the protocol which states that employees who are working more than 25% of their time in a country would be subjected to the social security contributions in that country. However, if they work 25% or less, then they will be bound by the rules in the country where their employer is residing. So to conclude, it's important for employers to be mindful of this, but if it is a posting which has happened after the 1st of February, then there shouldn't be anything to worry about. The contributions will continue in the United Kingdom. It's important to look into an A1 certificate just to confirm for employers who are posted on a temporary basis into the EU, just to clarify their social security position. And this is something that we're going to keep on top of, and we will update as and when we are required to do so.